Good morning, everyone. This is a reading session with regards to civil procedure. We will discuss first, we will read actually the general principles with regards to civil procedure on based on the reviewer coming from Attorney Jello Agbayani. So first part would be the general principles. So definition of substantive law and remedial law. So substantive law creates, defines, and regulates rights and duties concerning life, liberty, and property. The violation of which gives rise to a cause of action. It makes vested rights possible. It is prospective in nature. While remedial law lays down the method or procedure by which the rights and obligations arising from the substantive law are protected, enforced, or given effect. So there are no vested rights because this is a procedure with regards to coming from the judicial department of the government. It is retroactive in application because there's no vested rights applicable to action pending and undetermined at the time of their passage. So under the 2019 amendments, here the 2000 amendments, the present appeal of the court, the present appeal to the court is not sanctioned because it is clear under Section 2, Rule 34, which is new, that any action of the court or on a motion for judgment on the pleading shall not be subject of an appeal. Rule 144 of the 2019 amendments provides that the 2019 amendments shall govern all the cases filed after the effectivity on May 1, 2020, and also all pending proceedings except to the extent that in the opinion of the court, their application would not be feasible or would work injustice, in which the case of procedure under the cases were filed shall govern. Since the application of the 2019 amendments would work injustice, the present case, they will not be applied. Abad versus heirs of Eusebio Abad Gallardo. Number two, rulemaking power of the Supreme Court. The Supreme Court shall have the power to promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure. In all courts, the admission to the practice of law, the integrated bar, and the legal assistance to the unprivileged. Limitations. Such rules shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. The power to suspend. The courts have the power to relax and suspend technical or procedural rules or to accept a case for their operation when compelling reasons so warrant or when the purpose of injustice requires it. What constitutes good and sufficient cause that would merit suspension of the rules is discretionary upon the courts. 3. Principle of judicial hierarchy. When courts have concurrent jurisdiction over the subject matter, such concurrence of jurisdiction does not grant the party seeking relief the absolute freedom to file petition in any court of his choice. Pursuant to this doctrine, a case must be filed first before the lowest court possible having the appropriate jurisdiction, except if one can advance a special reason which would allow a party a direct resort to the higher court. Section 5, paragraph 1. Article 7, Article 8 of the Constitution provides that the court exercises original jurisdiction over the petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. It shares the original jurisdiction with the RTC and CA as provided for under Section 9, Paragraph 1 and Section 21, Paragraph 1 of Batas Pambansa 129. By reason of the shared jurisdiction, the immediate and direct recourse of the court is frowned upon the following doctrines of hierarchy of courts. Rationale. It would be an imposition upon the limited time of the court, and it would inevitably result in a delay intended or otherwise in the adjudication of the case, which in some instances had to be remanded or referred to the lower court as the proper forum under the rules of procedure, or as better equipped to resolve the issues because the court is not a trier of facts. Exception, a direct invocation of the Supreme Court's original jurisdiction to the issue extraordinary writs should be allowed when or only when there are special and important reasons, therefore, clearly and specifically set out in the petition. Generally, a direct invocation of the court's positional jurisdiction to issue extraordinary writs shall be allowed when there are special and important reasons, therefore. Thus, in Rama versus Moises, the court recognized the following exception to the strict application of the rule of hierarchy of courts when there are genuine issues of constitutionality that must be addressed at the most immediate time. When the issue involved are of transcendental importance, cases of first impression, when the constitutional issues raised are best decided by this court, when the time element presented in this case cannot be ignored. Notwithstanding the foregoing, while the court notes that the petition presents at the very least a case of first impression, novelty alone cannot cure the inherent defects of the petition. Thus, those who seek relief from the court must comply with its rules. Mercado versus Lupena, penned by Justice Kagiwa. Next would be the doctrine of non-interference or judicial stability. This principle holds the courts all equal and coordinate jurisdiction, and it cannot interfere with each other's orders. The principle also bars a court from reviewing or interfering with the judgment of co-equal court over which it has no appellate jurisdiction or power of review. Applicability to administrative body. The doctrine of non-interference applies with equal force to administrative bodies when the law provides for an appeal from the decision of an admin body to the Supreme Court or Court of Appeals. It means that such body is co-equal with the regional trial court in terms of rank and statute, and logically beyond control of the latter. Please note, it applies only when the administrative body is exercising quasi-judicial power. Pursuant to the exercise of its quasi-judicial jurisdiction, the SEC stands as a co-equal body of the RTC. Hence, all orders and issuance issued by the SEC in the exercise of such jurisdiction may not be interfered with, let alone overturned by the RTC. If any or all of the said orders are erroneous, the Organic Act creating the Commission, Presidential Decree 902-A, provides the appropriate remedy first within the Commission itself and ultimately in the court. Nowhere does the law empower any RTC to interfere with the orders of the Commission, not even on grounds of due process and jurisdiction. The Commission is conceding arguendo a posible claim of respondents, at the very least co-equal body with the RTC. Even as such, co-equal, one would have no power to control uh, the other. But the truth of the matter is that that only the Supreme Court can enjoin and correct any actuation of the Commission. RCBC versus Plast Print Industries, also penned by Justice Kagiwa in June 19, 2019.